The leadership of the Osun State chapter of the People's Democratic Party has accused the Attorney General of Federation, Prince Lateef Fagbemi, SAN, of turning the Federal High Court to an annex of his chambers by interfering in the judicial process filed before the court. Chairman of the PDP, Honorable Sunday BC, who made all the allegations on Thursday, also called on the Chief Judge of the Federal High Court to immediately probe some letters conveying judicial decisions affecting the Osun local government crisis being signed by his aides. BC spoke in Osogbo at a press conference. Abiodun Taiwo, Inside Links TV, Osogbo.
We have invited you here today to address a very disturbing development in the handling of the Osun local government crisis at the Federal High Court. It concerns two controversial letters issued from the office of the Honorable Chief Judge of the Federal High Court, and we are calling for nothing less than a thorough proof of those letters. First, let me say this clearly. Judicial powers cannot be exercised by proxies or by personal assistants. They are reserved exclusively for judicial officers, judges. Unfortunately, that is the abnormal situation we are confronted with and which informed the press conference. On the 21st of August 2025, a letter was issued and signed by one Joshua Ibrahim Aji SB, who described himself as Special Assistant to the Honorable Chief Judge of the Federal High Court. In that letter, judicial functions were purportedly exercised, assigning a judicial duty to a judge of the court. This is a gross aberration. A special assistant is not a judicial officer, and judicial powers cannot be exercised either directly or by delegation through such aid. To make matters worse, another letter emerged dated 2nd September 2025. That one was not even signed by the so-called special assistant. It was signed by an unknown, unnamed individual on behalf of the special assistant. The letter purported to assign a case to a judge, something that can never lawfully be done by anyone other than a judicial officer. Even more suspicious, that letter was delivered to the Osun State Council on the 11th September 2025. More than a week after it was reportedly signed, we have every reason to suspect that that letter may have been backdated to achieve political ends. This suspicion is strong because when the case came up on September 8, 2025 in Abuja, neither the court nor the party to which it was addressed spoke about the letter. Gentlemen of the press, this is bizarre, unprecedented, and unacceptable. The law is very clear. The power to transfer a matter from one judge of the Federal High Court to another is provided for under the Federal High Court Act. Such transfer can only be sought through a formal application in open court before the presiding judge handling the matter. It cannot be done through secret letters or shadowy signatures. In the 21st of August letter, the office of the Chief Judge even suggested that the case would become nugatory if not had during vacation. But that is a question of fact and law that must be determined in open court with all parties act. For an advertive letter to prejudge the issue shows bias and prejudice and compromises the independence of the judiciary. The abuse of power becomes even clearer when we note that the 2nd September letter was addressed directly to Chief Akeoluchibi SAN, counsel to the third defendant, the Attorney General of the Federation, at a time when that defendant had already been withdrawn from the matter and seeks to be a party in the case. How can the office of the Chief Judge be writing letters to a party that had no proper process before the court? This is strange, disarray, and deeply troubling. We are left to wonder, why is the office of the Chief Judge afraid to have this case heard in Osogbo Division of the Federal Court, where it was filed? Why this backdoor manipulation of process by persons unknown to the law? Our position is clear. This matter must be returned to the regular Federal Court in Osogbo. Any application for transfer must be made openly before the regular presiding judge. That is the law. Anything else is illegality. Let us also state clearly that the Honorable Attorney General of the Federation is not innocent in this matter. The AGF has consistently disregarded the substantive judgment of the Federal Court in suit number FHC OSCS 103-2022, delivered on 30th November 2022, which was affirmed by the Court of Appeal Appellate Division in CA AK 270-2025, delivered on 13th June 2025. Instead of respecting this judgment, the AGF has been instigating manipulations against the people of Osun State and their duly elected PDP local government officials. The AGF's action keeps suggesting to reasonable members of the public that he has effectively turned the Federal Court into an annex of his chambers. He has encouraged certain APC chairman and councillor to embark on reckless judicial adventures, seeking on an elongation of a tenure they never had. He has even filed a similar application before the Supreme Court. Let it be noted that when what the AGF initially sought through his counsel, Chief Archaeology Sam, was only an expeditious hearing during vacation. That was the request. But by 2nd September, the story changed. Suddenly, a transfer directive was issued to a vacation judge, instructing him to act as a substantive judge, something no party had applied for. Gentlemen of the press, this is not a mere technicality. This is a deliberate attempt to erode judicial independence and impose political bias on the courts. We, the People's Democratic Party in Osun State, therefore call on the Honorable Chief Judge of the Federal Court to immediately probe these irregularities. He must investigate how and why persons purportedly working in his office who are not judicial officers are signing letters that carry the force of judicial authority.
From Osogbo, Insight Links TV, Toyosi Popola.